Joe Burns was born and raised in central New York and became active in Republican politics at an early age. Shortly after graduating from Syracuse University and Albany Law School, he began working for New York State Senator John DeFrancisco, who at that time represented Onondaga County in the state Senate. After working for Senator DeFrancisco for 4 years, Joe was hired to be the Deputy Director of Election Operations at the New York State Board of Elections, where he was involved in the state's historic transition from lever to optical scanning voting machines. Since leaving the State Board of Elections in 2015, Joe has represented candidates for elective office in election cases throughout New York State and has served as an attorney for the Erie County and New York State Republican committees. Joe currently resides in Amherst, New York. Please welcome our speaker, Joe Burns.
Thank you, Howard. Hope you'll indulge me. I don't have as good a voice as Howard's. But since the last time I spoke here on this topic in winter 2020, there's been a lot of changes, whether it's election law or society for that matter. And a lot of the election law changes, a lot of the new developments have certainly been things that none of us have really liked that much and have not been good or positive from our perspective. I think our members, the Republican and conservative members of the state legislature put up some good fights, but that's what happens. This is what happens when you don't have the majority. I did send Sean Marie some materials that she asked me to communicate to everyone. If you're interested, shoot her an email. She can send those off to you. There's a number of different things in there, whether they be bills or the election law update from the State Board of Elections, a few other things. So there's been a lot that's happened in the last couple of years, so let's dig right in. I believe I have an hour for this presentation, but hopefully we can get through it quick enough and allow you to ask some questions. So in just last year, I'd like to structure this and let you know a few of the legislative changes that have been made, and then follow that up with some recent court decisions that I think will be important for you as you go back to your communities and with your committees and your candidates. And then we can take a look at what might be happening in the next few months and the next year, what's going to happen down the road. So in 2021, the legislature made something that was in my opinion, a pretty historic change to part of the election process that I'm sure everyone here has dealt with at one point or another, and those are opportunity to ballots. I assume everybody here is familiar with those. These are the petitions that get filed to trigger a write-in primary. As you know, it's usually the minor parties, and of course there's only two that remain, the Conservatives and the Working Families Party. Minor parties have historically been the objects of attack of these opportunity to ballots. The change that was made is pretty historic, and I actually think it's something that the folks in this room are probably going to be happy about, oddly enough, since it came from a democratically controlled state legislature. So opportunity ballots are still allowed, they're still permitted under the election law. But there's been one really major change. And that change is that those who vote in the opportunity to ballot primaries can only vote for a candidate, or I should say, can only have their votes counted should the candidate whose name they write in, if they are a member of the party. So, for instance, an opportunity to ballot is triggered. Someone wants to write in my name for whatever reason. Well, I've enrolled as a Republican. That vote, that write-in vote, would not count. Somebody, however, wants to write in Jerry's name. Well, Jerry's enrolled as a conservative, of course. That vote would be counted. So, for instance, an opportunity to ballot is triggered. Someone wants to write in my name for whatever reason. Well, I've enrolled as a Republican. That vote, that write-in vote, would not count. Somebody, however, wants to write in Jerry's name. Well, Jerry's enrolled as a conservative, of course. That vote would be counted. this is really something that I would think that the minor parties, the Conservatives, the Working Families Party, would actually like. So while opportunity ballots are still allowed, they have, in my opinion, effectively been eliminated. What would be the point to trigger an opportunity ballot if you couldn't write in the name of somebody that is not an enrolled member of the party? A little history or a little background. I believe that the intention, I think there's actually been some media reports to this effect. The intention behind this was some Democrats in the state legislature unhappy that Republican candidates in a few counties around the state had some great successes in winning the working families line through opportunity to ballots. So that's a little bit of the background to this proposal. Again, I think it will probably have the interesting effect is to help the Conservative Party out as well. That's the first change from 2021 that's I think is worth noting. Second, another change, in my opinion, monumental change to our election process. The governor signed into law, the former governor signed into law a bill that will allow a candidate who loses a primary, who also has another party nomination, to decline that additional party nomination after the primary, within 10 days after the primary election. Like I said, major change in our election process. I think we're all familiar that frequently a candidate in a Republican primary, a Democratic primary with a minor line, conservative line, working families line, or back when they still existed, the Independence Party or even the Green Party, would in some instances be stuck on the ballot if he or she lost a party primary. Oftentimes we'd jump through hoops and do some maneuvers to get that individual a nomination for another office. It was frequently, it was common practice for a candidate who was an attorney to be nominated for Supreme Court in a judicial district that was more or less uncompetitive. That would be a way to get that individual off the ballot. That's no longer going to be needed. Or I should say that is still out there as an option, but if you had the opportunity to decline your additional party nomination after the primary, you would think a candidate would do that. That also then opens up the window for that second party to nominate another candidate, quite possibly the one who was victorious in the primary. As you might be aware, previously, and this is still in effect, a candidate with an independent nomination who lost a party primary would be able to decline that independent nomination within 3 days of the party primary. That's still in effect. That 3-day window is still in effect for the independent nominations. It's a 10-day period, though, for the declination, after the primary, for the declination of an additional party nomination.
Joe, who fills that? If that declination takes place, which committee what is the process for filling the vacancy?
It would not be the committee to fill vacancies, for starters. Your committee to fill vacancies on your petitions goes out of business, I guess, 8 days prior to the primary election. So it would end up being the power of the appropriate party committee. So I guess I would suggest consult your party rules. The answer might be different given, the answer I think will be different given the office in question. I always like to look at everything in addition to the legal angle, but from the political angle. So who benefits and who loses? I'm not sure if one side or the other necessarily benefits or loses. Whether it's the Republicans and conservatives, or Democrats and working families, I think it's really up to the individual circumstances. Where it could be a plus, it might not be. But I would say keep in mind that this is an option, that this is an opportunity and an option that didn't exist in previous cycles. A couple new provisions that I think it's fair to say are leftovers from some of the changes that were made with absentee voting during the pandemic. Number one, at the end of 2021, Governor Hochul signed into law a bill that would make the online absentee request portal permanent for all elections in New York State. This was something that had emerged really, I think, in the early days of the pandemic in 2020. There is a statewide system run by the State Board of Elections. In addition, Erie County has its own homegrown system, as does the New York City Board of Elections. So that is now permanent. Another provision that might be a leftover from the pandemic and the rise in absentee voting because of it is, and I do think this is a major change, a very significant change to the election law, and something that I don't think any of us have really wrapped our minds around how it's going to work in practice, whether it's in terms of counting ballots by the boards of elections, or really how we run campaigns, how we do politics. So the governor signed into law a bill that would start the processing of absentee ballots prior to the election. That might sound a little strange. Certainly does to me. Although I will say it's not unheard of in the U.S. There are states that have undertaken this. So this bill, and it will be in effect for this year's general election, will require that boards of elections, I believe it's within 4 days of receiving an absentee ballot, begin the process of processing those ballots. This would end on election night with the tabulation of those ballots. So presumably, the only ballots that would be able to be fought over after the general election would be those ballots that arrive after the general election. This is quite a change. It's quite a monumental change. In addition, it also, the bill that was signed into law also amends part of Article 16 of the election law, which is the article that contains the judicial proceedings. And the changes, and again, I'm not sure if anybody has totally figured out what was intended by the legislature or what the changes mean, but I can assure you that the changes to Article 16 will make it harder to challenge these ballots in court. Like I said, I try to look at everything not just from a legal perspective, but also a political perspective. And if you have absentee ballots being processed and being canvassed prior to the general election, you as a candidate or as a party chair, I would assume, are going to want your volunteers at your local board of elections, reviewing ballots, possibly objecting to ballots. If that's what if that's where you're sending your volunteers in October, in late October, well, that means fewer volunteers out on the streets, fewer volunteers knocking on doors. And again, this is a big change, and I don't think people have really processed it, really wrapped their minds around what this is going to mean legally as well as politically. Just to look back a little bit, the Congressional District 22 race, the seat that Congresswoman Teddy Dow holds, that wasn't decided until February 2021 for an election that took place in November of 2020. I think we had approximately 30,000 absentee ballots. I think it's a safe assumption that the vast majority of those arrived at their local boards of elections prior to election day. So if this bill had been in effect, making challenges to those ballots would have been much more difficult, and there certainly would have been less to fight over and less to contest in a judicial proceeding. So keep your eye on what's happening with this new provision of the election law.
Joe, is it clear that the candidates and their people will be able to review the ballots that come in before the process before election day? They will be? They
will be able to review them. They will be able to review them, lodge objections. What I think is still a bit of an open question is how much of an ability will the candidates, their supporters, be able to make those challenges, preserve those challenges for further judicial review. And you know it as well as I do from the Congressional District 22 wars. That was a big deal. That was a big part of everything. And not having that ability, I think will likely require us to reevaluate some of our strategies and how we do things. But to your basic question, yeah, you know, and don't forget these proceedings, the work of the boards of elections. Whether you're a candidate, whether you're a supporter or a party chair, or just a member of the public, you are entitled to be there when they're doing their work and review what they're doing. That's good question. Another recent law that was cited by Governor Hochul, which didn't get a lot of attention, but I think is actually pretty important. And that was a bill, and I actually think we'd probably all agree that this is a good idea, a bill that would restrict the governor's ability on calling special elections. The bill that was signed in last summer by Governor Hochul gives the governor a window after a vacancy for Congress or state senate or state assembly with some caveats, which I won't get into today, restricts the governor's ability and when they can call a special election, when they can set a special election. Previously, there really had been nothing in the election law or the public officers law that would restrict when a governor could call a special election, or how long a governor had to call a special election. We saw in recent years one governor, no longer governor, play games and play politics with that. Specifically, when we had a vacancy in Congressional District 27, out in my neck of the woods in western New York. If you recall, the governor waited many months to call that special election. I believe this was also the case in the Staten Island, Brooklyn Congressional District from a few years back. In both of those instances, Governor Cuomo was sued in the district, the downstate district, in federal court. The governor sued, that we sought to have a judge order the governor to call a special election. The new provision, again with some caveats, gives the governor only 10 days after the vacancy to make that call of a special election. Again, I generally think this is a good idea. I suspect most of the people in this room do as well. Any governor shouldn't be able to play politics, to set a special election at a time that would be most beneficial to their party or their political allies. As I was involved in that Congressional District 27 litigation, and in the course of it, I discovered that one of the grievances listed by the Continental Congress in the Declaration of Independence of King George III was that he was allowing vacancies in public offices to remain and not allowing for elections or other processes to take place to fill those vacancies, leaving the colonists unrepresented. I can assure you that it was the first and only time I was able to cite the Declaration of Independence in any legal papers. It was awfully fun to do it, though. I think our former governor probably has some commonalities with King George III as well. Also looking back to 2021, there were some successes that I know we're all aware of and we should be happy about. What I'm thinking of is the 3 constitutional amendments that the voters of New York defeated. The so-called redistricting reform. It's not often we can clap about anything in this state, so you deserve to do it. The so-called redistricting reform, the no-fault absentee voting, and same-day voter registration, all 3 were defeated. So what does this mean going forward? Certainly, the legislature could propose those amendments again, but again, it's a long process. It requires 2 consecutively elected state legislatures, as well as a vote of the electorate. But going forward, what does this mean? Absentee voting. The protections for absentee voting remain in the Constitution, in that the legislature can only allow for absentee voting under certain very specifically defined circumstances, such as a voter being out of the county or a voter being sick and unable to vote in person. With regards to the same-day voter registration provision, the state constitution allows the legislature to reduce the time to register before an election, at most to 10 days before the election. It's longer now, but the legislature has proposed to reduce that to 10 days before an election. There's an interesting wrinkle with that, in that I don't believe it's been signed into law yet, but the legislature already in January has passed a bill to reduce that time to register to 10 days prior to the election. What's interesting about that, though, is that 10 days prior to an election bumps up against early voting. So, in my opinion, doesn't that enact de facto same-day voter registration in certain circumstances? So we'll see where that goes. And then finally, the so-called redistricting reform. That means that the 2014 amendment that was approved by the voters is still in effect. Something I'm sure. I think I saw John Fass was going to talk about redistricting later. So something I'm sure he'll bring up, and sure it's something that you'll hear a lot about in the next week or so. So let's look back at a couple notable cases from 2020 and 2021 that may have some application to what you do, what your candidates do, how your committees do business. First, the Seawright case. This is one that was ultimately went to the State Court of Appeals. You may have read some about this. I think the New York Post was all over it at one point. This was the incumbent state assemblywoman from Manhattan who was being challenged by a Republican challenger who was a doorman. And the incumbent Democratic assemblywoman, without getting too far into the specifics, missed certain petition filing deadlines. And as you recall, this was in the early days of COVID. She claimed that she had had a COVID exposure and that required her to quarantine, and that's why she missed these deadlines. And therefore, even though she missed the deadlines and even though she didn't comply with the mandates of the election law, she should be allowed onto the ballot anyway. The Supreme Court in Manhattan agreed with her, agreed that she should be back on the ballot. The Appellate Division, First Department, agreed with her. She should be back on the ballot. The Court of Appeals thought otherwise. And the Court of Appeals said you have strict deadlines laid out in the election law. The legislature certainly could have, knowing that the pandemic was hitting in March of 2020, could have amended the election law to allow candidates that didn't get on the ballot to have a COVID excuse or a COVID exposure excuse. Of course, they didn't. And so, Court of Appeals said that Assemblywoman Seawright should be off the ballot because she didn't comply with the petition deadlines laid out in the election law. So, what does this mean for what you do, how you do business, how your candidates do business? Number one, keep your eye on the political calendar. Number two, no excuse is going to be good enough to get you on the ballot if you miss a deadline that's been specifically set forth in the election law. COVID exposures or other circumstances, regardless of how valid they are, regardless of how worthy they are, they're not going to be good enough to let you or your candidates back on the ballot. So know your deadlines, know the calendar. If, God forbid, you are going to be in a circumstance where you can't comply with the statutory deadlines because of a health matter, make alternate plans. No excuse is going to be good enough. Going forward, 2021, some of you from downstate may be somewhat familiar with this case. In the 13th Judicial District, which is Staten Island, Richmond County, there had been no Supreme Court seats that were on the ballot for the 2021 general election. And I don't know all this history, but it's if you allow me, I'll dive into it for just a little bit. The Democrats had circulated their judicial delegates, qualified their judicial delegates, and should a vacancy occur, they would be able to nominate candidates. With the Republicans and the Conservatives, I think it's a little murkier as to why they didn't have judicial delegates. But let's just understand they did not have judicial delegates. Now, keep in mind, this is all taking place in March and April of 2021. And at that point, again, there were no seats scheduled to be on the general election ballot for Supreme Court in the 13th District, Richmond County. But late in the legislative session, state legislature created a number of new judgeships throughout New York State, including 2 Supreme Court judgeships in the 13th District, Richmond County. Well, you had a situation where only one party, the Democrats, had judicial delegates. And so I'm sure from their perspective, they thought that they were going to walk into 2 Supreme Court seats without a contest. The Staten Island Republicans knew what their chances were, knew what the playing field looked like, and knew that things were grim if they didn't try something. They convened a meeting of their county committee, or their executive committee, filed a certificate to appoint judicial delegates to fill vacancies among the judicial delegates for the 13th District. Filed this with the New York City Board of Elections. An objector out of Staten Island, a Republican by the name of John Clinton, filed an objection to the certificate and to the subsequent nomination that was made by these delegates at a judicial convention. Mr. Clinton, however, did not file his objection to each and every judicial delegate on that certificate. Like I said, he commenced a lawsuit in Manhattan. The judge said that, number one, the Staten Island Republicans did not have the power, not have the authority to fill vacancies in judicial delegates. They should have elected those at the primary election. However, I guess these are all important points, but this is maybe the most important point. The judge said, however, while on the merits Mr. Clinton is right, procedurally, he did not name each and every judicial delegate in his objections, nor did he name each and every judicial delegate as a respondent in the court proceeding, meaning that necessary parties had not been named. And the judge said we need not get to the merits because procedurally Mr. Clinton hadn't done everything he was required to do, and therefore the proceeding is dismissed, and which left the certificate that was filed, the nomination that was filed, valid. The decision by Judge Edmead was affirmed by the First Department, and the Court of Appeals refused to decline to take the case. So there's a number of things that I think you could draw from this. I think you could.
So I'm going to interrupt Joe here, but you can all hear me. There are 2 very conservative judges that were elected only due, eventually the voters voted, but we kind of knew that Staten Island was going heavy GOP last year. There were 2 excellent judges who were only elected because of the persistency of Joe Burns. He's not going to say that. It was his persistency. Is the only person I know that actually takes the view that we go forward because they may mess up. And that persistency, you use this as an example, but this has happened to you before, where your persistency has won a case where it was on technical grounds. That's really, really impressive.
And I think I probably said this to you at the time, but I'd always said it to the guys in Staten Island, that on the merits, we're probably going to lose, and we probably should lose on the merits. However, I'm sure everybody here, you've been around, you know this, there's a lot of twists and turns, and there's a lot of traps in the election law. And how do you get your opponent to fall into those traps? I think that's exactly what happened here. The odds of us winning on the merits were slim to none at best. But what's to be taken from this? Number one, winding this all back some. Regardless of whether you know you have Supreme Court candidates, Supreme Court judgeships on your general election ballot or not, you better run delegates. There's a lot of things that could happen. You're running your delegates in March. There's a lot of things that could happen. Judges die, God forbid. Judges resign and do different things with their lives. State legislature could create new judgeships as they did last year. Sometimes judges go to prison. Who knows? There's a lot of things that could happen that will put a judgeship on the ballot for Supreme Court. A lot of things could happen that you just don't know they're going to happen. So you have to every single year run delegates. That's number one. Number two, and this was actually one issue that I forgot to mention. The objector here, Mr. Clinton, one objector who resided in one assembly district of Staten Island, which entitled him to object to and file this lawsuit against the delegates in that assembly district. He could not, he had no ability to object to the delegates from the other three assembly districts. Keep that's something to keep in mind. Make sure your objectors are able to vote for the individuals they are objecting to. And also, of course, make sure they are in the right party if the objection relates to something specific to the party. For instance, this certificate of nomination might be different, of course, for a designating petition, let's say. Third point, make sure you object to everybody. Make sure if you're in litigation, make sure you name everybody who possibly could be a respondent as a respondent. If there's one thing I learned in law school, and there might only be one thing I learned in law school, it's the answer to the question of who do you name as a respondent? Everybody. Name everybody under the sun. It doesn't hurt. It might cost you another few bucks in serving these individuals, but it doesn't hurt to be over-inclusive rather than under-inclusive. With the election law, you're dealing with the shortest statutes of limitations in all of New York law. So you basically only have one chance to get it right. If you mess up, you're gonna find yourself where Mr. Clinton did here. And then really the last point of things I believe you could take away from this is really to have the same mindset that our folks in Staten Island did. They knew what they were up against. They knew that if they did nothing, what the outcome would be. That the Democrats have candidates and they would win without opposition. I think it's fair to say they took the perspective of what have we got to lose? We're probably going to lose anyway. We're probably going to lose on the merits. Why not give it a whirl? And I think when you're in a situation like that, you've got to really think about it. You've got to have that mindset of what's your potential for success, even though the chances are remote. As Jerry and I were saying, there are so many traps in the election law. How do you potentially maneuver your adversary into falling into one of those traps? One more case to mention from 2021, something for all of you to keep in mind. We'll say it's a tool at your disposal. This is one out of Monroe County. Conservatives were able to successfully disenroll what I guess I would call fake conservatives. Some individuals in one town who were, we'll say, NIMBY types, said about one particular local development project, had enrolled as conservatives, and had in their attempt to sway the party nominations, an attempt to sway the outcome of the election. The Monroe County Conservatives, to their credit, went after them, went through the process of a disenrollment, which is something that's not often done in the state, certainly not often done successfully. Went through the process of the disenrollment and were successful and managed to keep those individuals from voting, managed to, number one, throw them out of the Conservative Party, and number two, keep them from voting in this town primary. So I just mentioned that as something that you should all keep in the back of your minds, that it's not an easy process. It is time consuming and sometimes can be expensive as well. But that is a tool in your tool chest. You do have the ability in Article 16 of the election law to disenroll people under a narrow set of circumstances as members of the party. Taking a look forward, couple things to look at going forward in 2022. The governor signed into law a bill that will allow for the COVID excuse, I guess I'll call it, this idea of being afraid of contracting a communicable disease, making you eligible for an absentee ballot. Now, it's something that the Conservative Party fought in 2021, litigated this in Niagara County and at the 4th Department, unfortunately unsuccessfully. But going forward, and there was a similar, almost identical law. But going forward, have the circumstances changed enough with COVID and with some of the government mandates? Have the circumstances changed enough that maybe this law now runs afoul of the state constitution? I don't know. I think it's something that there's going to be a lot of discussion about in the days and weeks ahead. But that was something that the governor signed into law just in the last couple weeks. In the governor's budget proposal, 2 points, 2 provisions. One I already mentioned, the reduction in time for registering before an election, reducing that to 10 days. That's in the governor's budget proposal. And then the second provision would require a poll site on contiguous property of a college or university that has 300 or more registered voters to have a poll site. It's pretty obvious that this is the governor's, this is an attempt to make things more convenient for college students to vote. A couple other things looking ahead in 2022. After the 2022 general election, actually the day after the 2022 general election, the public finance program that was enacted in the 2020 state budget takes effect. Remains to be seen what the practical effects of that will be and how that might change politics, or if it changes how politics is done in this state. You would think that it would push candidates towards fighting even harder for smaller dollar donors. Another question, will the progressives, will the DSA members of the state legislature potentially push for a more generous program? Will the more establishment Democrats get cold feet about this program? A lot of questions remain, but that's something to keep on your radar as it comes into effect the day after the general election in 2022. A couple more things that are floating out there for the 2022 session. In 2021, the Senate Elections Committee, led by a Democratic senator from Brooklyn, held hearings throughout the state on our electoral system and on our county boards of elections and how they operate. The majority issued a report with their findings and their suggestions, and I believe that's part of the materials that I sent to Sean Marie, so she could send her an email, she could get that to you. How many of those proposals, how many of those suggestions will find their way into legislation, and how many of those will find their way into law? Number of really, I guess I would say, out there ideas that were in that report, including, my opinion, most notably, changing the structure of the New York City Board of Elections. And I believe I heard within the last week or so that there was actually a bill introduced by a Democratic senator and a Democratic assemblywoman that would enact those changes. Another thing, item that's out there is a state voting rights act. I'm not entirely sure of the specifics, but I know it's certainly been something that's been on the minds of many Democratic elected officials, that the pre-clearance provisions of the Federal Voting Rights Act were effectively rendered useless by the Supreme Court a few years ago, and I think some of the intention is to enact some of those provisions at the state level. So that's another item that's out there, that could be out there to keep your eyes on. I think I have, about 15 or so minutes remaining, so I don't know. I'm sure there's probably a question or two out there.
Yeah, representative Dutchess County, Joe. Good to see you again.
How are you?
We have four, Terry, am I correct? Four colleges, four liberal colleges in Dutchess County. And how do we check some of these students when they consider their address at the college their home address, but they also live in Oregon? I'll just use Oregon as an example because I hate the state. So how do you keep track that if they apply for an absentee ballot in Oregon, vote here for Joe Biden, and absentee ballot vote for Joe Biden in Oregon? How do you prevent that? What measures are in place to stop that? Part two, does New York City also have a database that Dutchess County can check for residents that live in Dutchess County for 4 days a week and live in New York City for free, and they vote in both? How do we, those two issues are major issues.
Great questions. I know the situation in your county very well, and you've spent probably hours, if not days, on the phone with your election commissioner talking about some of those over the years. Number one, if you're voting in Dutchess County and in Oregon, or in Dutchess County and New York City in the same election, you're breaking the law, and you can be prosecuted and should be prosecuted. I guess my suggestion, specifically for you, Don, is work with your county election commissioner, because he's a fantastic guy and knows what he's doing. Look, if you do find that somebody has voted twice in the same election, don't be afraid to make a complaint to the district attorney or the U.S. attorney. It is a crime. I guess I would unfortunately say you don't have a tremendous number of tools at your disposal. And if somebody does spend most of their year in, or I take that back, somebody lives with mom and dad in Manhattan, but is in a dorm at Vassar, registers to vote at the dorm. Unfortunately, between the courts and the state legislature, it's pretty tough to fight that. They're going to be able to vote, unfortunately, from Vassar as opposed to where mom and dad live in Manhattan. I know that's been a major problem for you and probably some other folks in the Hudson Valley, maybe not with colleges, but maybe with summer homes. Very, very tough. It's gotten very tough to challenge somebody's residency, somebody's registration. But I guess stay vigilant, and if you do see somebody voting in the same election in two places, don't be afraid to make a complaint. It's probably not the answer you want, but unfortunately.
The Democrat socialists keep on talking about voter integrity, and they know I just brought up a major issue.
Yeah, I agree. It's a problem. It's probably more of a problem in your county than maybe anywhere else. I saw another heat.
Thanks, man.
Yeah, right there.
That's a lot to digest. Are your remarks available? Did you say you left them when it was showing real?
They're going, these remarks, I guess you're aware, this is all on Facebook Live right now. This is being broadcast, this whole meeting. Additionally, all the remarks will appear on our YouTube channel in the very near future. And I believe you did leave some direct material. But his actual remarks will be available on our YouTube channel at cpnys.org, or right now the show is live, and it will be available for anyone who's on Facebook for a very long time. But the written remarks, are also available. Not remarks, but your outline is available.
Okay. And also, could you come back to the situation where early processing may preclude a judicial review, and why would that be?
Because the state legislature altered the provisions of Article 16, unfortunately. I think it remains to be seen how it actually works, but when you commence a lawsuit to challenge the absentee ballot, for instance, you bring it under Article 16. I forget the specific section, but you bring it under Article 16. Some of the language in the bill that was signed into law by Governor Hochul would suggest that there are additional barriers to making those challenges, or I should say, having that judicial review of your challenges. This is brand new, so I don't think anybody really knows how it's going to play out operationally. So I guess I would say stay tuned, and we'll see where that goes. Chris?
So do you have any opinion on the constitutionality of people who are non-U.S. citizens voting, for instance, in New York City elections or other elections across the state and country?
I strongly believe I spent some time doing some research on this in the last few weeks. I strongly believe that under the state constitution and under state law, non-citizens cannot be allowed to vote in local elections. I feel pretty good about that as well. I should mention there's a lawsuit that's been filed in Richmond County, Staten Island, challenging that new New York City law that would allow non-citizens to vote in local elections. I think the city will ultimately lose that. I think it's pretty clear under the state constitution that only citizens are eligible to vote in any election. think yeah.
Mr. Brown, what would the mechanism be to begin the clarification of what is a residence for voting purposes?
The definition of resident or what qualifies as a resident has really been broadened over the years by the courts. Now with unified democratic control of the state legislature and the governor, they've actually enacted a couple bills that bring the statute in line with where those court decisions have gone. And this is, I know, Don brought it up, and this has been a big problem, I know, for folks in the Hudson Valley especially, where you have folks with their summer homes, folks registered to vote in their summer homes, but spending really the rest of the year in New York City. Honestly, I'm really not sure. If fighting that battle is really going to be a winner long term. It's really been broadened. Where you can register to vote, where your residence is. Honestly, the courts have made it more of a state of mind than anything else.
Joe, I just want to let you know there's a star exemption where you, wherever you have your star exemption is where you're a resident. So that's a court decision.
Yeah, and I certainly would. I mean, if you're taking a star exemption, you're saying that's your residence.
Right.
So I certainly wouldn't be taking a star exemption at my home in Brooklyn and then voting at a summer home in Greene County. Look, if you're a college student, you're probably not filing for a star exemption to begin with because mom and dad own the home.
But it covers 85% of the registration problem, a residential problem.
Yeah.
Do you have any update on what happened in Sullivan County with residency requirements?
I guess I'm not too familiar with the specifics of that.
Someone kicked you off the board because
I mean, is it similar to the? I mean, I know this is a pretty hot issue at times in the Hudson Valley.
There were a couple of town elections that were determined by residents. I don't know the final outcome of that.
Yeah, the one thing on the residency, I guess I would just say is it's as the years have gone on, it's gotten tougher and tougher to throw out a ballot because of somebody allegedly not being a resident. So I guess I'm just saying, generally speaking, I wouldn't pin your hopes on changing the outcome of an election because of something like that.
Joe, can I get you to address, last session we talked about school board elections. Could you talk about the timetable for petitioning for school board elections across the state as opposed to most of what we've been talking about in this one?
One thing I am not an expert on is school board elections. And I guess I should let you know that the school elections are governed by the education law, not by the election law. I believe there are a few places where I guess they would be governed by the election law. The one that's coming to mind is in the Syracuse school board races, which run in the general election, and the candidates run on partisan lines. But I can't say that I'm an expert on school district elections. Although I guess I would just note that I think your period for petitioning is going to be obviously different from when your other races run. With again maybe a couple exceptions. I know Buffalo School Board this year will for the first time be running on the general election ballot, although they will remain nonpartisan elections.
Okay, thank you. Thank you, Joe.
Thank you.